lord. There is no point, my lord, in boring, my lord. At some stage, the courts are also saturated, my lord. We feel that we still want to bring our case home, despite knowing that rightly or wrongly, our submission has reached there, my lord, whether it's in my favor or against him. Lord, please come to page 767. This is a new point, my lord, I'm beginning with. The point is, my lord, other side, the learned counsels, my lord, relied upon Article 213 to substantiate their interpretation. Seven, 6, 7, para 49. Lord, the argument was based upon Article 213. The interpretation which was canvassed by my learned friends, my lord, the learned counsel, was that this clearly shows that there is no discretion in the governor. Lord, as a matter of fact, Mr. Datar went to the extent of saying, and I, my lord, as a constitutional interpretation, seriously object, that legislature has a right to pass even a void bill. It will have to be assented to, and only your lordship can set it aside. So
that's their argument.
Yeah. So there is no option. Governor has not, forget 3 or 4, that's not the debate. There is no option at all. Then why have the governor at all? That's the simple argument. But, my lord, one of the argument was that promulgation of the ordinance. Please see, my lord, the language used. I'll read, my lord, whatever is necessary, and I'll skip what is, my lord, already either orally paraphrased or earlier argued. If at any time except when the legislative assembly of a state session, so if the assembly is in session, no ordinance can be issued. Simple. Or where there is a legislative council in a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinance as the circumstances appear to him to require. But I am not saying that read discretion here. It has to be his discretion. There is no doubt about it, but that's not my submission. That's not the only submission.
No,
provided that.
His satisfaction or the satisfaction rendered on the basis of the aid and advice of the Council of Ministers.
Therefore, I am saying it is not, my lord, my submission that it is his.
Normally, the ordinance making power is of the executive.
I am not disputing that. Therefore, I said that that's not my submission. I preempted, my lord, that it has to be as per aid and advice. But there is a discretion even after aid and advice. That is what I want to show. Provided that the governor shall not, the constitutional prohibition, without instructions from the president, promulgate any such ordinance if, kindly come directly to B. Lord, please read A first, Lord, so that it can be read in context. A bill containing same provisions would, under this constitution, have required the previous sanction of the president for introduction thereof into the legislature, like Article 30, 31, etc., etc., my lord. B is very relevant, my lords. He would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president. If it would have been a bill, he would have considered it necessary, despite aid and advice given to him by the Council of Ministers, that no, this needs reference to the president. I must refer it to the president for his assent. Now, please see, my lord, see, an act of legislature of a state containing the same provisions would, under this constitution, have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. So, like Article 254, 254(2), the repugnancy. There is a repugnancy. So here, my lord, it makes it very clear that the framers of the constitution says that in the first part, yes, you will act as per aid and advice, as my lord, the Chief Justice very rightly pointed out, but he shall not do it if these three contingencies and one of the contingencies be, he would have deemed it necessary. When the bill comes to him, he would have deemed it necessary to reserve the bill containing the same provision for consideration of the President. In that case, he needs prior instruction from the President in case of an ordinance. Now, please come to para 51. It may be pointed out that Article 213, page 767, para 41, 51. It may be it may be pointed out that Article 213 is a power to promulgate ordinances. The ordinance is promulgated by the governor himself. Subclause B will have to be read in the context. In view of the nature of the ordinance itself and the fact that the governor is promulgating the ordinance, the question for the grant of assent, first option under Article 200, will not arise, because ordinance, there is no question of granting assent. He himself is promulgating the ordinance. Similarly, second option of withholding under Article 200 will also not arise. The assembly not being in session is the precondition for exercising the power of promulgation, and therefore option of returning would not arise. Thus, there is only one option for the governor out of the four options mentioned in Article 200, and that is referring the bill for the President's assent. Now, my lord, this provision came in for consideration before a 7-judge bench of this Honorable Court, my lord, which was not cited till date, my lord, because this Article 213 argument came, my lord, orally in the and in written submissions also in the reply. Therefore, I am, my lord, respectfully urging the counter. I'm not in rejoinder. This is how the central government interprets the Constitution. Please come to, my lord, Krishna Kumar 768. In Krishna Kumar Singh versus State of Bihar, a 7-judge bench of this court held as under. But then 231 is quoted. I am skipping that. The first of the above condition arises in a situation such as the proviso to Article 304B of the Constitution. Under Article 304B, the legislature of a state is permitted to impose reasonable restrictions in the public interest on the freedom of trade, commerce, or intercourse with or within the state, notwithstanding anything in Article 301 or 303. The proviso requires the previous sanction of the President before a bill or amendment for the purpose of Clause B can be introduced in the state legislation. An illustration of second requirement, that is point 2 above, point 2 where B is provided by Article 200 of the Constitution, under which the governor is required to reserve for consideration of the President any bill which, in his opinion, would, if it were to become a law, derogate from the powers of the High Court so as to endanger the position which it is designed to fill by the Constitution. Situations where the assent of the President is required, then point 3 above, are illustrated, 254, etc., where he will have to refer it to the President. There is a clear repugnancy, that's what the court said, illustrated by Article 254, where a law made by the state legislature on a matter enumerated in the concurrent list of the 7th schedule is repugnant to a law made by Parliament. The state law will prevail only if and to the extent to which it has received the assent of the President. These three situations make it abundantly clear that while exercising the power to promulgate an ordinance, the governor is not liberated from the limitations to which the lawmaking power of the state legislature is subject. So, my lord, as a matter of fact, Article 213 aids my interpretation that despite there being contrary aid and advice, the governor has the room for discretion. But that's the respectful submission supported by, my lord, a 7-judge bench judgment, my lord. And I have, my lord, now given the contingencies for such reservation over and above the express clauses under the Constitution cannot be illustrated exhaustively, but may depend on the following factors. My lord, please pause here for a minute. my lord, I have cited in my initial respectful submissions and even during these submissions that there are judgments which says that irrespective of constitutional provisions, there are discretions available. Calling the minister, calling someone to form the ministry, etc., etc. Lord, in none of those cases, in all those cases, the Supreme Court was very clear that these are only illustrative and not exhaustive. Because the Supreme Court was very clear in my submission that there may be circumstances which may arise in future where, other than the illustrations which we give, the governor may have to exercise his discretion. I'll come to that, but I have given, my lord, the broad parameters within which, my lord, he will have this discretion, where the bill is capable of subverting the constitution. Nobody can dispute this, my lord. Where the bill is undermining the constitution, where the bill erodes the principles of democracy, where the bill is of such a character that it has a national implication. My lord, therefore, my lord, I have gave an example of Punjab water dispute. My lord, 4 states involved: Punjab, Haryana, Rajasthan, Delhi. There was an international treaty with Pakistan, and one assembly said that we revoke the agreement entered into. And, my lord, now we are faced with an argument that you have no option. Even a void bill, you will have to grant assent to.
This court granted stay of that.
Yes, obviously, my lord. But, my lord, that would not take away the power of the governor. My lord, kindly, my lord, appreciate. Your lordships are right. Your lordship stayed it. But that would not have taken away the power of the governor also to withhold. That you can't do this. This affects the federal structure. 4 states are affected. The center is affected because there is an international treaty in place. My lord, then, my lord, second submission, my lord, which I have made, but I wish, my lord, some of the judgments to be, only relevant parts to be shown. My lord, I gave certain examples, my lord, that suppose the assembly passes a law that we will have a separate force. They may not term it as an army. That would protect the borders of my state, for example. Or a person belonging to a particular community will not be permitted to have any trade and business. These are extreme examples. Now, my lord, this section of my written submission deals with, then in past also, Supreme Court has dealt with extreme examples while interpreting Constitution of India. Because what your lordship decides today will be the foundation as to how the country will govern, number one. Number two, the Constitution will have to be interpreted with the harshest of the examples because it will have to withstand the test. There are many acts which are passed today which possibly would not have been contemplated, my lord, 70 years back. Now, please see, my lord, I have given the example of Lord Nani Palkiwala giving extreme examples that somebody surrenders the sovereignty, takes away the right to vote from a particular class of persons, or confers right only to a particular class of persons. Somebody say, my lord, some government come out with a say, as a, my lord, cheap publicity gimmick, that we will not tax anyone except some industrialists. These are not, my lord, these are, my lord, possible potential examples. Supreme Court has examined extreme situations. Please come to page 771. Lord, in Keshwanand Bharti, only I'll read the highlighted part. Lord, if this is so, Lord, please see the extreme examples which are tested. If this is so, a political party with a 2/3 majority in parliament for 4 years could so amend the constitution as to debar any other party from functioning, establish totalitarianism, enslave the people, and after having effected those purposes, make the constitution unamendable or extremely rigid, this would no doubt invite extra constitutional revolution. They have considered that if we interpret it in a particular manner, this kind of bills also can be passed. Mr. Palkhiwala gave an example that suppose Article 368 is amended, conferring power to amend on the executive, that henceforth the government will amend the
So
constitution.
these observations
Yes.
are in response to the argument that the parliament's powers to amend be read. So rejecting that argument, these observations have been made.
I'm sorry, I'm saying the same thing. I'm unable to convey it the way, my lord, your lordships have very pithily conveyed. What I'm saying is that while answering the proposition that we have unbridled power, the court has examined and conceived extreme situations, that we have to keep these situations in mind, that if we allow
Your submission is that while interpreting these provisions, we also have to take into consideration the extreme situations that may arise in,
I have brought my point.
arise in future.
Yeah, I have brought
Therefore,
my,
we have to be cautious while
yes.
holding whatever we are proposing to hold.
Yes. My lord, only, I'm not, my lord, then reading rest, but my lord, one judgment, my lord, which I found it interesting, is again, my lord, a 7-judge bench, State of Rajasthan versus Union of India. The lordships were shown in a different context. Here, my lord, the example which was given was that this was a case of 356, my lord, Precedents rule. Janta government, my lord, dismissed all Congress governments in the state. And that was under challenge, and my lord, not all, 7, my lord, if I is right, 7 state governments in the state, in different states. And the question was, what can be the judicial review of 356? So 356 is an executive power. It's not a legislative power, that's a separate thing, unlike Article 200. The court says that we will examine only if there are certain exceptional circumstances, and one of the example, your lordship may come to para 773. Another extreme example, but an interesting extreme example. Page 773, my lord, the highlighted part. Lord, take for example, if your lordship, my lord, can come to that. Court is examining the ability or power of judicial review or the restrictions thereof. Take for example, a case where, I'm sorry, my lord, your lordship gets, my lord, somewhere, my lord, the highlighted part, 5th, 7th line from the top, last word is take. Take for example, your lordship gets, my lord.
Yes.
Take for example, a case where the president gives the reason for taking action under Article 256 and 356 and says that he is doing so because the chief minister of the state is below 5 feet in height, and therefore, in his opinion, a situation has arisen, then we can interfere, etc., etc.
This one is very reasonableness.
Point is,
Very unreasonable.
point is, there can be extreme, there will have to be extreme examples on which you test the constitution.
At this point, it's an age-old technique to test the correctness of a proposition. You examine the extreme situation. It's an age-old technique, so there's nothing new.
Correct.
You take
Lord.
this point, you can go ahead.
Yes, my lord. 776, my lord, I have seen withholding as a separate option, my lord. And I'll just,
Your proposition is that while interpreting the provisions of 200 and 201,
yes,
we will have to take into consideration the extreme situations that may arise.
arise.
And therefore, we have a cautious approach.
No,
For the governor to consider that.
no, my lord, for the governor, yes. Therefore, withholding can be an option. Therefore, withholding is an option. To be used rarely, my lord, I cannot, my lord, argue that he can use it wherever he feels. But something so shockingly unconstitutional, something so, suppose some legislative assembly passes a bill that henceforth we will not be a part of Union of India. Would he, my lord, return it? Would he grant assent? Would he refer it to the president? The only thing which can be done is to withhold the assent. Therefore, I said, my lord, I'm not repeating it, that there are only 20 instances, my lord, in last 50 years. Now, Lord, withhold is a separate, my lord, action, a separate independent option. I have already argued it, but my lord, I was just trying to assist your lordships on the question, what is the meaning of the word falls through, what is the consequence of withholding of the assent? My lord, falls through, as my Lord Justice Narasimha, my lord, pointed out, that it's not a constitutional term. It's not a term used. My lord, Constitution uses the term lapsing. But lapsing is a separate phenomenon. My lord, suppose a bill is moved, but the assembly is dissolved, etc., then the bill lapses. But withholding, every judgment of the Supreme Court uses the word, in case the governor withholds the bill, it falls through. From where? We were, my lord, searching. From where the Honorable Supreme Court got these words? I'm not reading it, but please see wherever amendments were moved and were not accepted, the Constituent Assembly debate says that this amendment is not accepted. Please come to 778. I'm not reading it. 778. 778.
8.
Yes. Therefore, my lord, from the beginning of the conceiving of the Constitution, the word falls through is that it
Like
dies.
yesterday we said then they were put before the Constituent Assembly and the Constituent Assembly did not approve of them. So therefore it fell through.
The governor, my lord, withholds it. Therefore, if the
Why
word...
you equate the governor with the Constituent Assembly?
No, my lord, I'm sorry, my lord. And that's not the comparison I'm making even remotely. My lord, that's not my submission. My lord, my submission, I'm sorry, my lord, there is some limitation. I'm unable to communicate properly. My submission is where the word falls through.
The origin of falls through.
Comes from.
The origin of falls through. The origin of falls through.
Origin of falls through.
It's
Falls through.
constitutionally dependent.
Falls through means dies. Amendment not accepted, it dies. From this, my lord, every judgment of the Supreme Court, larger bench judgments, says in the context of withholding that if it is withheld, the bill falls through, meaning thereby it dies. That's the only limited purpose.
Unless.
My lord, that I have already, my lord, I don't wish, my
Proviso
lord,
is followed.
repeat it, my lord, I have already, my lord, argued that, my lord, then the chart is given. Unless, my lord, I don't think, my lord, I'll take that, my lord, further.
Unless my lordship permit me, my lords. My learned friend gave this sheet to your lordships, which is said withheld. So it falls through, but it was passed.
Yeah?
This very bill was passed. Governor's assent was given. According to my learned,
After sending it back to the.
yes, his government has given. According to him, the moment he withholds it, it falls through, contrary to my lord's own action.
No, my lord, I
This
do
was
not know
passed,
from
note
where
the
he
date,
gets it.
Assent given on 26 to 21. It became an act 15 of 2021. Anyway, I'm sorry to interrupt.
My lord, this is a reference made by the President of India. It is not necessary that one party will only appoint the governors. The argument from the other side is that perennially we will never have our governors. Let's not, my lord, go into that. My lord, here I'm not going into this question. My lord, here what happened was, let me tell you.
The Constituent Assembly was considering the provision of governors. The expectation that the framers of the Constitution had was that it would be an existence in harmony.
Correct.
Normally, while appointing the governors, the provincial governments would be, that was the expectation that
My
time.
lords, the system has functioned with harmony. This has a recently started phenomena with Delhi government. Something happens 32, something happens 32. Otherwise, my lord, there are several governments, my lord, communist government, Congress government, Congress in center, BJP government in state. Did your lordships get 32 petitions? They were being taken care of. And what my learned friend is, my lord, possibly assisted wrongly is this bill was withheld and therefore it fell through. Thereafter, in 2021, some new bill was introduced.
This very bill, don't.
It cannot be this bill, my lord, after follow. Lord, Sibal Sahab,
Take it up.
don't take instructions from unreliable sources.
You can place that
I will place it.
on record. Yes.
But my lord, that again, this is only to answer.
Only to examine whether after withholding, the governor again sent it to the legislature. The legislature
No.
again passed the bill and thereafter the.
No, it cannot. Lord, therefore, my only purpose of showing this is that prop-
May I say this, Lord? Your Lordship permits.
he's
In Tamil
obsessed
Nadu-
with Tamil
Tamil
Nadu. I
case,
understand, my lord.
Can-
He-
Governor gives a reason.
They do, yes.
And sometimes it is in writing,
Yeah, no, mostly in right. Yes, your lordships are right.
for informal or formal, the reasons are communicated.
And there is an end.
And after the communication of those reasons, there is nothing which preclude the legislature
To pass a
to
fresh.
reintroduce, reconsider
Exactly.
a bill where certain modifications may or may not.
Correct, my lord, correct.
Send it.
I bow down, my lord. That's all I am saying. The file, my lord, which culminates into this declaration contains correspondence, reasons, calling for some explanation, some details, meetings between the chief minister and the governor. Lord, this my lord, adversarial approach had never been taken. Since 50 years, we have the example. Now, my lord, page 780. My lord, I have given the authorities on plain meaning, etc. My lord, I am not troubling your lordships.
Page
But
7,
80.
780, my lord, 780.
80 you said.
Yes, my lord, that the interpretation has to be plain textual meaning and not, my lord, anything else, my lord. But I am not reading them, my lord. They are settled propositions. I have cited judgments, my lord, which were relevant. My lord, most of them are constitution bench judgments, and only one paragraph, my lord, your lordships can permit me to read. My lord, Jai Shri Lakshman Rao Patil, my lord, that reservation matter, page 781. No, it's a basic proposition, but very well articulated. I'm not reading it because otherwise I'll have to cross my time limit. But just see the highlighted part. The first and primary rule of construction is that the intention of the legislature must be found in the words used in the legislature itself.
there can't be any dispute with regard to
Therefore, my lord, I didn't read, my lord. I'm not reading that.
golden rule of interpretation.
Yes. Now come to 785. My lord, kindly treat them as read. That's all. I'm citing it. 785.
That allowance, you must give it to at least all five of us.
No,
That we know the basic rules of interpretation.
the very fact that I did not read and said that I'm not reading because your lordships are aware, I started with that, my lords. Lord, 785 is a very important, my lord, point, which was raised by my learned senior Mr. Gopal Subramaniam. Discretion, aid and advice, and the necessary implication. My lord, allow me, my lord, to spend, my lord, 10-15 minutes on this point. Lord, his argument was that the discretion is only, kindly, my lord, discretion is only provided when it is so provided either by or under the Constitution. Correct? No, that was his argument. Now, please come to para 90 at page 785. So, therefore, my lord, the argument was that wherever either by or under discretion is not conferred, discretion does not exist. Correct, my lord? That was the submission. And very well articulated, my lords. My lord, para 90. The Constitution confers certain discretionary powers expressly. Certain discretionary powers are read as implied either because of the nature of the power, the subject matter of the decisions, or the functionary exercising the power. Article 200 is an example of certain implied discretions when the fact situation under which the government is supposed to act, governor is supposed to act, so requires. Even under Article 163, there can be implied discretion not to be guided by aid and advice. This is for the reason that sometimes exercise of power under aid and advice defeats the power itself. My lord, take example of MP, Special Police Establishment Act. Lord, suppose the chief minister is facing allegation and there is a question of sanction. 197 section or section 17 PC Act or 19 PC Act. He would still, my lord, I am saying, my lord, as a constitutional principles, I am not taking an extreme one side view. He would still require, my lord, the guide and advice of the Council of Ministers. But he can still say that, no, this is clearly a biased advice. I am not bound by it. The council may say that don't grant sanction. And none of these provisions, my lord, the distinction was sought to be drawn that they are statutory provisions. No, the provision for which under which sanction is required, PC Act or Bharatiya Nyaya Sanhita, may be statutory, but his power which he is exercising is under Constitution. Because he is the appointing authority under the Constitution, he decides whether to grant sanction or not. There is nowhere which is mentioned that this would be done in his discretion. But that is by very nature of the power an implied discretionary power. Look, kindly read it further. It is submitted that, for example, of under the Constitution, by the Constitution there is no dispute, under the Constitution. Discretion is evident in the following. The power to summon assembly does not use the word in his discretion. However, it is recognized that in certain situations, the said power can be exercised in his discretion. He can summon the assembly, my lord, to ask for the floor test, etc. Second, the power to order a floor test does not use the word in his discretion. However, it recognizes that in certain situations, the said power can be exercised in his discretion. The power under the second proviso to Article 200 does not use the word in his discretion. However, it is recognized that in certain situations, the said power can be exercised in his discretion. Lord, the power to grant sanction against the chief minister or ministers does not, I have not already pointed out. Then 356, it doesn't say in his discretion, but the nature of the power is such. He would never get advice from the Council of Ministers that you report under 356. So, my lord, to say that it has to be either by the Constitution or under the Constitution, lord, would be a wrong constitutional interpretation. Lord, for which, my lord, for example, lord, my lord, MP Madhya Pradesh Assembly, my lord, Shivraj Singh Chauhan, my lord, when this issue, my lord, came, lord, this honorable court has said that this has to be done as per the discretion of the governor. Whom to call, when to summon the legislative assembly, floor test, etc., etc. They are neither by or under the Constitution. The discretion is not by or under the Constitution. It is read as an implied power because of the very nature of the power. Then, my lord, kindly come to 95. And my lord, this again, my lord, I have my lord, raised a very serious concern. I will not say objection. How you selectively place the judgments before the court. This was done before the division bench in Tamil Nadu case and unfortunately repeated before your lordships. Despite my pointing out that two paras are not read before the division bench and therefore the division two-judge bench.
That's nothing new in the Supreme Court.
Pardon?
That's nothing new in the Supreme Court.
Their lordships.
Not only paras, but even the sentences are selectively read here.
Some words are not read. That's anyway, my lord. Lord, please see Nabam Rabia. Para 95. My lord, kindly allow me to read 95. It is submitted that it is startling that few states opposing the reference place considerable reliance on the judgment in Nabam and read numerous paragraphs of the said judgment and specifically place reliance on paragraph 147, 148, 149, 153, 154 and 155 in order to advance the argument that the governor does not have discretion while dealing with matters concerning Article 200. The said portions of the judgment were also relied upon in order to interpret Article 163, subclause 2. The reliance of the other side on the above stated paragraphs in the judgment in Nabam Rabia and the conclusions drawn therefrom is A, wholly incomplete, and B, a clear attempt to mislead this honorable court. While the above stated paragraphs of the judgment state that there is a limited area in which the governor can exercise discretion, the said judgment itself, while making the said observations, from para 147 to 155, specifically at para 151 and 152 notes that as far as Article 200 is concerned, specific reference of 200, the governor can exercise the said power in his discretion. There was a similar incomplete reading before the two-judge bench in Tamil Nadu case by the petitioner. At paragraph 301 in Tamil Nadu judgment, the Honorable Court was led to commit the mistake by skipping or omitting the most relevant paragraphs in the same context. The state government is supposed to be a virtuous litigant and should avoid skipping or omitting the most relevant parts. Lord, please see 155(3).
No, you say that specifically at paragraph 151
Yes,
and 152. Where are those paragraphs?
Lord, next page, my lord. Next page, my lord. 151, my lord.
Yes.
The important observations your lordship gets.
Yes.
The important observations in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. A relevant extract of the same is reproduced below, and thereafter please see the bold part. But the entire thing, my lord, is dealt with, but for paucity of time, I am reading bold part. The governor's discretionary power are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of the chief minister, etc., etc. We are of the considered view that the inferences drawn in Justice M.M. Panchi Commission report extracted above are in consonance with the scheme of functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of the constitutional interpretation. My lord, if your lordship would, my lord, kindly note, I don't wish to read.
That sentence is preceded by an observation that the governor's powers are not unlimited, but restricted.
I'm sorry, my lord. My lord, I'm sorry.
So you want to refer to this, that there is a specific reference to Article 200.
200, specific reference to discretion, the constitution power to withhold. There is a specific reference, and the court says that we endorse this view. This was not read, and if your lordship were to read para 301 of Tamil Nadu, my lord, this is not placed before the court, and here also it was not placed.
Trying to take us to that judgment.
Pardon, lord?
Place the relevant portions of the Nabamit.
That's this Navamund.
No, I know.
No,
No, I'm sorry, man.
Navam Rebia doesn't say
No,
there's a
no,
power to
no,
withhold.
yes,
Navam
yes,
Rebia does not say that there's a power to withhold. Navam
Please,
Rebia
sir.
is not dealing with 200.
Please, sir, why are you agitated? I'm
Don't say
making a
Navam Rebia says there's a power to
constitutional
withhold.
interpretation. You are unnecessary.
You are saying Navam Rebia says there's a power to withhold.
No, I
Navam
Lord, I will
Rebia
not
does
enter
not say
into
that.
this tutu meme. You are doing.
Make statements
I'm
like that.
making, my lord, a constitutional interpretation. My lord, it may not be suitable to their interpretation, my lord.
You made a
May not
statement
suit.
which is wrong.
1, 2, 4. Anyway, my lord, I'm not.
Anyway, Mr. Solicitor, the entire judgments are on record.
Your lordships may.
All the judgments are. And
Your lordships,
when I came here in 2019, it was difficult to cope up with the speed of the lawyers. From first line of the judgment, they would read to the 10th line, from 10th line to 20th line. Then we had to read the judgments, entire judgments at home. So this is nothing new here.
By now we are well used
We
to
are
it.
very well used
Clear
to.
method was that the poor was appearing for the appellant will take the court to judgment
This one
after
all.
judgment after judgment.
With an exception of the.
I read it.
Read this paragraph also. So you have read entirety of judgments and then moved on till the other side. Nowadays, only
Huh,
court
your
said,
lordship,
court-
correct.
court said-
With,
But
both
in
sides.
this case, I read it
With-
saying
with
that
an
it was not read before the.
With an exception of
System
Justice
that you have
Narasimha,
followed.
all four of us must have found it very difficult in the beginning
My lord,
to adapt to the
5 of us.
practices here.
My lord, your lordships can say on this side,
My
we also.
brother, Justice Chandrakar must be yet,
He's still groping.
My lord, I have also come to this.
from first line, somebody would go directly to the 10th line of the judgment, from 10th line to 15th, from 15th
And I
to
think
20th,
practice-
and we are lost.
practice in all the high courts is first the paragraph containing the facts
Yes.
will always be read. So as to understand the
Understand in
context,
what context the observations are made.
Yeah.
only to understand the
But
context.
my lord, just my lord,
Well-
be clear on my part. When I started with this matter, my lord, I did.
We are not on
Yes,
individuals.
We are
your
not
lordships
individual.
are.
Practice,
Only
practice.
Let us leave it at that. Let us leave it at that. Now, my lord, next question.
At least your next generation, we should make them clear that they should not adopt this technique of reading.
Yes,
Maybe because of time
your lordships are
constraints
absolutely right. Absolutely right.
Go back to the old system.
and multiple
My
variables.
lord, in Samsher Singh, there was another, my lord, thing. Justice Krishna Iyer's judgment was read as concurring judgment. I must say, Justice Krishna Iyer does say it's a concurring judgment, but it is partly a dissenting judgment or a minority judgment. But this happens, my lord, many a times, my lord, that broadly the judge, the learned judge says that, my lord, once I had that experience, my lord, in a very sensitive case where me and Mr. Sibal were on the same side, when the pronouncement started that the bench is broadly in agreement, and I lost 2 heartbeats, and thereafter I realized that it was 3 versus 2. So sometimes, my lord, that happens. Lord, please see Justice A. N. Ray, my lord, the majority view, according to me, my lord, and concurring but partly minority view. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, please see, my lord, it's not exhaustive list. My lord, throughout your lordships have been very careful that these are illustrative because we do not know what contingency would arise. Reading further, to illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union, so and so, your lordship,
Yeah, this we already read.
come to 56. My lord, the bottom, the broad, my lord, the bold part. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. Now, my lord, come to Justice Krishna Iyer's judgment. Here, my lord, I may be pardoned, my lord, if I skip some words, because I may not be able to pronounce many of them. Because of language issue, my lord, not for any other reason. Kindly see, my lord, from the beginning and then the highlighted part. We declare the law of this branch of our Constitution to be that the President and Governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well-known exceptional circumstances.
Situation,
Yes,
situations.
situations, without being dogmatic or exhaustive. Then again, my lord, Justice Krishna Iyer also says that this is not exhaustive. These are illustrative. Please, my
Never
lord,
be exhaustive. It can never be exhaustive.
cannot be. My lord, they other side, my lord, Mr. Other side, my lord.
They also did not say it is exhaustive. They only said that wherever the certain provisions of the Constitution, either directly or by implication, have provided for discretion, there only the governor can exercise the discretion. The powers under 163 does not fetter him with an unfettered discretion.
My lord,
And that also appears to be from Dr. Ambedkar's speech. But Dr. Ambedkar said that it is too premature to argue, to dilate on that point, because hereinafter we will be considering the provisions wherever a discretion is vested with the governor. And maybe we can take this article for reconsideration after that, but somehow it never fell for reconsideration.
I'm not, my lord, joining issue. Your lordships are right. But why I am emphasizing this is this. The state of Karnataka's written submission as well as oral submissions, written submission para 21 specifically says that only, my lord, I'll just read, my lord, it's a short para from the written submissions, your lordship need not open. Thus, the governor is bound by ministerial advice in the discharge of his functions. Article 163 requires the governor to act in his discretion by or under the constitution only, bold, underline. In the following circumstances, then articles are quoted. And, my lord, it must have missed their attention, my lord, I believe. Article 164 and 174 not quoted. Summoning of the assembly, calling upon the chief minister to prove his floor, it's not quoted. Because they say that only where it is provided under the constitution, there is a discretion. My lord, therefore, my lord, they treat these instances as exhaustive. I'll complete this. My lord, please see, my lord, Justice Krishna Iyer's minority view, my lord, though which my lord, his lordship says it's a concurring view, but this part, my lord, is not in tune with the majority. We have no doubt that the Smith's statement, so and so, regarding royal assent holds good for the president and governor in India. This is contrary to the majority view. The refusal of the royal assent on the ground that the monarchy strongly disapproved of a bill or that it was intensely controversial would nevertheless be unconstitutional. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course, a highly improbable contingency or possibility, or possibly if it was notorious that the bill had been passed in disregard to mandatory procedural requirements. But since the government in the latter situation would be of the opinion that the deviation would not affect the validity of the measure once it had been assented to, prudence would suggest the giving of the assent. Look, this is not what the majority has said. In what I have quoted, my lord, in para 54 to 55, 56. This part is a discordant note by Justice Krishna Iyer. That's all. Now, my lords, may kindly come to Lord. Lord, I have already told you, my lord, assisted your lordships by saying that all judgments which I have quoted here say that these are illustrative and not exhaustive, which were read, sought to be read as exhaustive, my lord. So I am not, my lord, going into it. Lord, now I come to, my lord, my second last point, my lord. That is, no mandamus can be issued to the governor or the president. And Article 361. My lord, this, my lord, I may take, my lord, 10 minutes. And, my lord, there is, in my submission, my lord, a direct judgment in A.K. Roy, where, my lord, this issue is considered. The question is, my lord, there are three categories of cases your lordships are dealing with when the governor's power is concerned. The first is purely executive power, namely the power under Article 356, etc., the power to grant pardon. That is, my lord, first case where your lordships have said that we have the power of judicial review. My lord, please don't treat this as an argument of arrogance that you cannot go into it. It's an interpretation that this aspect is non-justiciable. That's as a constitutional proposition. Your lordships have said that even in cases of 356 or in Shatrughan Chauhan, your lordships have said the power to grant pardon within a particular time limit, etc. The judicial review is read, though very, 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 very restrictively. Second category is, my lord, category like Article 200 and 201, which is legislative in nature, my lord, which I have already pointed out. Now, please come to, my lord, page 793. Para 112A. The issue of justiciability of precedents and the governor's exercise of functions under Article 201 and 200 respectively must receive a nuanced interpretation and must not be conflated with usual principles of judicial review. The question of denial or of assent to a bill or the action of the governor to refer the bill to the president is not akin to or comparable to the exercise of his executive powers, such as pardon or imposition of precedence rule. Apart from being qualitatively different in terms of the functions, the following factors need to be considered. The suggested exercise of judicial review in case of Article 200 and 201, unlike other instances, involves 3 steps. Prescription of a timeline. 2. Quashing of a decision of the governor to withhold assent or quashing of a decision to refer the bill to the president. Quashing the decision of the governor to resort to first proviso instead of choosing either of the 3 options in the main part. And 4, a direction to withdraw the reference made to the president or returning a bill. Well, these are the 4 possible contingencies your lordship will have to resort to if your lordships were to exercise the power of judicial review and make this decision making justiciable. Lord 113. In none of the cases involving the exercise of power by the president and the governor has this court ever imposed a one-size-fits-all time frame, dehorsed the nature of the action and its complexity. Each case turns on its own peculiar facts. Now, please, my lord, read, and this is very, very important judgment, not cited by anyone so far, on justiciability. Lord, this is A.K. Roy versus Union of India. It's a constitution bench judgment. We may now take up for consideration the question which was put in the forefront by Dr. Gatate, namely that since the central government has failed to exercise its power within a reasonable time, we should issue a mandibus calling upon it to discharge its duty without any further delay. My lord, kindly pause here for a minute. I'll just give the brief background. My lord, Justice Suryakant, my lord, was right, my lord, that fact situation will have to be given. In case of Article 200, the legislative process commences from introduction of the bill and ends with Article 200. It's a part of legislature. This was a case where a bill became an act, but the government did not notify it because it becomes effective only when the central government.
There are many acts which will come into effect from the date on.
From the date of it is
Official notification in the
Notification.
official.
And government was not, my lord, doing that, government of the day, and therefore, my lord, a writ was filed that direct the government to notify the act, meaning thereby to bring the law in force. Grant of assent also brings the law in force. This also brings the law in force, and therefore, my lord, I am reading this judgment. Our decision on this question should not be construed as putting a seal of approval on the delay caused by the central government in bringing the provisions of Section 3 of the 44th Amendment Act into force. I'm sorry, not even law. Even the constitutional amendment was not brought into force. Article 22. I am thankful to my learned. That amendment received the assent of the President on April 30, 1979, and more than 2.5 years have already gone by without the central government issuing a notification for bringing Section 3 of the Act into force. But we find ourselves unable to intervene in a matter of this nature by issuing a mandamus to the central government obligating it to bring the provisions of Section 3 into force, even to the government. In my respectful submission, the threshold in case of the Honorable President and the Honorable Governor would be high.
But then the next sentence is more important.
I'm reading. I would not skip anything. The Parliament has left to the unfettered judgment of the central government the question as regards the time for bringing the provisions of the 44th Amendment into force. It is not for the court to compel the government to do that, which, according to the mandate of the Parliament, lies in its discretion to do when it considers it opportune to do. The executive is responsible to the Parliament, and if the Parliament considers that the executive has betrayed its trust by not bringing any provision of the amendment into force, it can censure the executive. It would be quite anomalous that the inaction of the executive should have the approval of the Parliament, and yet we should show our disapproval of it by issuing a mandamus. The court's power of judicial review in such cases has to be capable of being exercised both, please mark this, positively and negatively. And I'll say, my lord, why I'm requesting your lordships to mark this. If needed, it has that power positively by issuing a mandamus calling upon the government to act, and negatively by inhibiting it from acting. If you have the power, you have power of both positive as well as negative. If it were permissible to the court to compel the government by a mandamus to bring a constitutional amendment into force on the ground that the government has failed to do what it ought to have done, it would be equally permissible to the court to prevent the government from acting on some such ground as that the time was not yet ripe for issuing the notification for bringing the amendment into force. We quite see that it is difficult to appreciate that practical difficulty can possibly prevent the government from bringing into force the provisions of Section 3 of 44th Amendment after the passage of 2.5 years. But the remedy, according to us, is not the writ of mandamus. If the Parliament had laid down an objective standard or test governing the decision of the central government in the matter of enforcement of the amendment, it may have been possible to assess the situation judicially by examining the causes of the inaction of the government in order to see how far they bear upon the standard or test prescribed by the Parliament. But the Parliament has left the matter to the judgment of the central government without prescribing any objective norms. That makes it difficult for us to substitute our own judgment for that of the government. Government on the question whether Section 3 of the Amendment Act should be brought into force. This is particularly so when the failure of the central government to bring that section into force so far can be no impediment in the way of Parliament in enacting a provision in the National Security Act on the lines of that action. In fact, the ordinance rightly adopted, no, that's on fact. It is for these reasons that we are unable to accept the submission that by issuing a mandamus, the central government must be compelled to bring the provisions of Section 3 of 44th Amendment Act into force. My Lord, now this is followed in these two judgments which I am not reading, but please see, my Lord, the position which will emerge. My Lord, and in a different context, my Lord, Justice Narasimha, my Lord, did, my Lord, indicate that. My Lord, kindly, my Lord, examine this. I'm saying it, but what it means now. My Lord, kindly appreciate, my Lords. And I'm sharing this concern because your Lordships would be deciding henceforth what will be the course of action. My Lord, the 5-judge bench says that the power includes positive as well as negative.
Negative. No.
Do something.
No, the court rejects the prayer on the ground that if we hold that, we have a positive power. Then we also have a negative power to withhold the central government from enforcing
No.
the legislature.
No, my Lord. No, I'm sorry, my Lord.
Yes.
Court says that if we have the positive power to direct them, we also have, if we have negative power to prevent.
This has been observed while rejecting the prayer for issuance of mandamus.
Exactly, that's what, I think, my Lord, I'm saying the same thing. I am unable to, my Lord, articulate the way your Lordship, my Lords, are doing it. I'm saying the same thing, that if I have the, if the,
The judgment goes on further to say that if the as to when an act
your
is
Lordships
enforced
are
or
right,
not.
my Lord, I am respectfully submitting that only. Now, my Lord, visualize the situation. My Lord, the judgment of this court, my Lord, in Tamil Nadu says that if the president doesn't decide within 3 months, or the governor doesn't decide within 1 month, you come to us. Correct, my Lords? Now, state comes before your Lordships. The prayer would be, direct him to grant an assent. The question is, can that be done, my Lord? Can a writ of mandamus be issued to either the Honorable President or the Governor to grant an assent? But the problem doesn't stop there. My Lord, somebody moves an application or files a separate petition that no, prevent the Governor from granting an assent and refer it to the President because there are repugnancies. The 2 petitions will be listed before your Lordships. There can be, my Lord, some MLAs who will file a separate petition that no, prevent the Governor either to grant an assent or refer it to the President, but ask him to return it to the House because when the bill was passed, the chief minister was enjoying the majority confidence. Now we don't want that to happen. My lord, would your lordships be in a position to substitute what options the governor would exercise? If your lordships have the power of granting a positive mandamus that do something, your lordships can also say that don't refer it to the president, don't return it to the house, don't withhold it. So therefore, quite timate actions, my lord, are not permissible, and therefore, my lord, this exercise is non-justiciable. Lord, that is my respectful submission. Otherwise, my lord, your lordships, it's not the state government only which can come. Citizens can come. Member of legislative assemblies can come. And, my lord, as it is, my lord, happening,
The qualitative difference between the two situations.
Hmm.
There only the executive has the power to notify when an act comes into force. This situation, there is a question prior to that whether there is such a power with the
therefore,
government.
threshold will be more.
The governor.
It's
has
a greater
sufficient power of withholding. So it depends on that answer. Suppose we hold he has no such power, then mandamus will not arise. Suppose we say that he has no such power, then obviously it's a different situation.
No, correct, my lord. My limited point is, my lord, would it be possible for this honorable court, apart from being, would it be permissible to deal with such situations where there are 4 petitions raising 4 issues? One says grant assent, one says don't grant assent, one says direct him to refer it, one says direct him to return it.
There is a difference in situation, Mr. President.
Yes, my lord.
Requesting the governor through a direction, through a writ of mandamus, that you please take a decision within your prerogative under Article 200 is something different. Asking the governor to take a decision in a particular manner is altogether different. The power to issue a writ of mandamus.
Approved by the intervener. Your lordship's view is approved by the intervener.
Why?
That
He says
both sides
yes,
will
correct.
approve. Both sides might approve it.
Or the 3 sides. So he said that he will,
He is no side, my lord. He is
he said that
intervener.
he will be laying down a middle path.
No, he didn't lay any path, my lord, but is not definitely middle. Anyway, my lord, it's not going to. The lordships are right. But, my lord, question would still be, and forget, my lord, this matter or reference, would one constitutional organ issue a mandamus to another coordinate constitutional organ when there is a discretion available, when there are 4 options, where there is no time limit prescribed by the constitution, though otherwise time limit is prescribed.
Howsoever high, one be.
Yes, my lord, that applies to all 3 organs. I bow down.
So, as a custodian of the
Lord,
constitution,
Lord, I'll not go into that debate, my lord. That's not, my lord, a very, this is not an occasion.
we also have, we always say, I publicly say that I'm a strong believer in the doctrine of separation of powers. And though the judicial activism has to be there, it should not turn into judicial terrorism and
Judicial adventurism, as your lordship say, my lord.
at the
Yes,
same time,
correct, my lord.
if one wing of the democracy fails in discharging its duties, would the court, which is a custodian of the constitution,
My lord,
be powerless and return to sit idle with
Lord,
folded
I
hands?
have already made my submissions on that. I have also cited a judgment when a law, because let us be very clear, not only court, executive is also a custodian of fundamental rights of the citizens. The legislature is also a custodian of fundamental rights of citizens. Lord, everyone, all 3 organs. I have cited a judgment when the law was sought to be made that court is not deciding dispute. Please don't take it as an, Lord, it's a constitutional
we are
interpretation.
willing to listen to all the arguments.
Yeah, yes.
Yeah.
So, my lord,
That
my
we have no
respect.
power, we have no quarrel with that proposition.
Yes.
But then we are just.
Lord,
being-
my respectful submission is, my lord, that issuing a mandamus with regard to a legislative discretionary function of a coordinate constitutional functionary would violate the theory of separation of powers. And in my submission, this separation of power is a part of basic structure. Lord, I leave it at that. Lord, now, my lord, I come to, my lord, page 808. My lord. 08. Not as soon as possible. I'm sorry. Pardon me, yes.
Here.
No, as soon as possible. At the outset, my lord, I make it clear. My constitutional interpretation, with whatever limited understanding I have, is that as soon as possible cannot mean endlessly. There is no doubt or dispute about it. For which, my lord, and your lordships very rightly, my lord, prevented me from giving the empirical data. But since last 50 years, assent of 90% plus bills are given in 1 month. Even in case of state of Tamil Nadu, except these two, few disputed bills, the assents are given, Lord, at least we have the data from 2005, within 1 month. It cannot be, Lord, that the governor has a power to sit over the bill endlessly. That's not my respectful submission. Lord, the purpose by which the Constitution uses the expression as soon as possible is, my lord, this. Lord, every bill has its own context-specific issues. Sometimes it might need, my lord, consultation and collaborative exercise with the executive. Sometimes, and my lord, your lordships may, with my lord's experience, longer experience both on this side and that side, would, my lord, also appreciate this, my lord. Sometimes, because of a popular public perception, despite knowing that this bill may ultimately harm the state, the legislature is required to pass it to calm down the situation. And there are instances, my lord, I don't want to go into the facts, where the executive requests the governor that we have passed it, but you please hold your hands till the matter is cooled down. Sometimes the governor himself may feel that this is something so drastic which is taken because of peculiar fact situation. If I wait for 2 months, maybe the situation might change and I'll be able to persuade the government to either withdraw or to make some suitable modifications. Look, there are large number of such contingencies. And it is that, Lord, constitutional collaboration and consultative process which has worked successfully. Imposing 1 month and 3 months time limit would be self-destructing, apart from being not permissible under the Constitution. That leverage, that discretion shall have to be in the larger interest conferred. While saying that as soon as possible does not mean perennially sitting over the bill or sitting over it for 3 years or 4 years. There may be, my lord, good reasons to wait for 6 months. They are in discussion. Whatever, my lord, I don't want to multiply, my lord, the situations or exigencies. But there can be, my lord, a possibility that this straitjacket timeline, my lord, may not be a permissible, my lord, way of. And, my lord, there are several bills which, by its very nature, is required to be assented to on the next day. Why even 1 month or 3 months? So that is, therefore, my lord, the Constitution says as far as possible. As soon as, I'm sorry, not as far as possible, as soon as possible. It was a inadvertent error. As soon as possible. So while not taking, my lord, an extreme position that perennially sit over it, but I'm saying that it depends upon the fact situation, and please leave it to the constitutional wisdom of a coordinate constitutional functionary rather than binding him that you do it within 1 month, and if she doesn't do it, come to us. That may perhaps not be, my lord, the constitutionally correct course of action, my lord. And, my lord, I have given the judgment, my lord, they relied upon constitutional silence. That constitutional silence can be filled in. Lord, this is a conscious constitutional choice of words. Constitution is not silent. And even if it is silent, I would, I really, my lord, sometimes feel handicapped, my lord, that why I did not learn the lip reading, my lord. sometimes we can only, my lord, apprehend or, my lord, anticipate what must be going on the lighter side. Nothing turns.
We had a senior colleague at Bombay High Court. When the arguments were going on, used to do paintings.
He drew paintings. Well, that's the worst compliment a lawyer can get. Man. Compliment a lawyer can ever get that
Or a judge.
or a judge. Your lordships are right. Now, my lord.
He was into painting, carpentry, everything except
Judging. Lord, I'm not reading, my lord,
Yes.
but this is not a constitutional silence. This is a conscious choice of words and a conscious call to leave it to the discretion. I'm not reading the judgment. Number 3, this is not a Vishakha situation where your lordships would thereafter supplement something. Even if there is a silence, and silence is required to be cured or corrected, Article 368, for the Parliament to prescribe time limit with some manageable standards, with some condition or whatever, my lords.
like we have done in Telangana.
Yes. My lord, I have reservations about Telangana view and Punjab view.
No. Telangana speaker's judgment.
Yes. My lord, that was.
We have held that it is for the Parliament to decide
Yeah.
whether the speaker should be.
And another thing, my lord, he's a tribunal. My lord. Suppose some decision is to be taken, my lord. Suppose the governor is also a vice chancellor or chancellor. He is supposed to take a decision within 2 months. Or no time period is prescribed. Your lordships can issue a direction because he is acting in his executive capacity, purely administrative capacity. My lord, therefore, my lord, wherever Constitution has used some words or chosen not to use some words, it's a conscious constitutional choice. It's not, my lord, a silence which is required to be filled up by a judgment. So, my lord, my last submission. My lord, what now, my lord, after, my lord, if suppose, my lord, our submissions are find favor with your lordships, either fully, partly, whatever. The argument which was again, my lord, a very extreme argument was that you can do nothing about the Tamil Nadu view. I'm not on the judgment. Intra-party, the judgment is final. That's the law of the land and binds, my lord, us. I cannot argue contrary to it. But your lordships has the jurisdiction and power to declare that Tamil Nadu judgment is not the correct law. And that is what, my lord, as a last proposition, my lord, I wish to, my lord, submit. My lord, please come to page 816. My lord, I read it, my lord, but there are 2 or 3 paragraphs and I would wish to, my lord, reread it, my lord. Main emphasis, my lord, your lordship said, 816. Well, this is a 2G judgment, where your lordships would, my lord, remember, in the questions which were referred by the Honorable President, one of the question was whether this particular judgment of Justice so-and-so and so-and-so is a correct law. The court says intra-party we cannot go. My lord, that background in mind.
This is
Para
not part of
45.
the reference, Manad, I don't want to object, but this is not part of the reference. This is nothing to do with the reference. Judgment is not
Mr.
even referred to
Sipal
in the
Saab,
reference.
you
I'm
please
just
take instructions.
part of the reference, that's all.
My lord, I'm making this submission with responsibility and understanding what I am making.
But is there a question framed to that regard? So he will be only
Mr.
answering.
Datar has said that you cannot touch the law laid down.
That is not a question which is for consideration before us. We will be only answering what are the questions that are referred to us.
What
What
my
will be the consequence of our judgment? That's the
Lord, what Mr.
consequence.
Sibbal did was,
That
when
He
he,
is giving our opinion.
That-
only give me a minute.
So that somebody else may decide what is the consequence of our judgment.
But it's not, my lord, something, my lord, I am saying it with a sense of responsibility. He rightly objected at the right time. My lord, when he could not raise these objections, my lord, at the outset, when the preliminary hearing was going on, he said, look at this question, cannot be answered. Look at this question, cannot be answered, and re-raise preliminary objections. Mr. Datar specifically said, law laid down by Tamil Nadu judgment is the law of the land, and you cannot touch that law of the land, and I am entitled to respond to it, my lord. Please allow me, my lord, to read only 2 or 3 paragraphs of 2G judgment. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri judgment, which according to him prohibits this court from overruling a view expressed by it previously under Article 143(1). We are not persuaded to agree with the learned counsel. The paragraph has to be read carefully. Justice Sawant first considers the case of a decision of the court, whereas in the subsequent sentence, he considers a view of law expressed by the court and attempts to explain the difference between the approaches to these two situations. These words are sometimes used interchangeably, but not herein above. We believe that Justice Sawant consciously draws a difference between the two by using the word when further this court overrules the view of law after discussing the decision. My lord, kindly turn the page over. 817 and bold part. After the exercise of those limited options, the parties concerned have absolutely no relief with regard to the dispute. It is considered settled for eternity in the eyes of law. Lord, between Karnataka, Tamil Nadu and Union of India, and governor, for those bills, it has attained finality. Please see this. However, what is not eternal and still malleable in the eyes of law is the opinion or view of law pronounced by the court of reaching the decision. Justice Sawant in so-and-so clarifies that unlike this court's appellate power, its power to overrule a previous precedent is an outcome of its inherent power. When he says, then, my lord, it is quoted. This is a judgment in a reference while dealing with a contention that judgment and the view expressed cannot be touched.
Whatever we hold may not be applicable to the
Those bills, yes.
But the law would be what we hold.
Yes,
be applicable
it's not just, my lord, as said, it's only a report. Your lordships are not a reporting authority to the president. It was, my lord, unfortunate that such a word was even used. The honorable president has sought your lordships' constitutional interpretation, and your lordships are, my lord, giving the advice to the president. It's not just a report. And your lordships' inherent power, my lord, that's what the court says, can permit your lordships, my lord, to even overrule the view expressed while maintaining the decree intra partes. My lord, last at the foot, my lord,
in any case, the judgment of view taken by 2 judges on law would not be binding on the constitution.
The argument was it is binding because
on fact, inter-party.
Yes. I'm not on that. But argument of Mr. Datar was that is a law and therefore it binds even the advisory jurisdiction of this court. And your lordships cannot touch even the view expressed. My lord, kindly see the last line, last highlighted part. In fact, the overruling of a principle of law is, my lord, please see, my lord, page 817, paragraph 48.2, the highlighted part. In fact, the overruling of a principle of law is not an outcome of appellate jurisdiction, but a consequence of its inherent power. The argument was that if you overrule the view of law, you will be sitting in appeal over the 2-judge bench judgment. Court says, no, it's not appellate jurisdiction. It's our inherent jurisdiction. This inherent power can be exercised as long as a previous decree vis-a-vis lists inter partes is not affected. For those bills, my lord, that is final. My lord, somebody can, my lord, take a remedy whether there is repugnancy, not repugnancy, etc. Your lordships would not go into it. But your lordships can say, and in my respectful submission, and prayer that please say that that's not the correct law which is laid down. My lord, last point, my lord. My lord, I have dealt with all, my lord, the submissions of my learned senior friends. My lord, only one submission was made by the intervener, my lord. I don't know, my lord, what was the purpose, but he relied upon Article 374 that federal court judgment is binding. I don't think, my lord, your lordships would be going into that because the federal court judgment is being binding or not. But there is a judgment of your lordship saying that federal court judgments are not binding to the Supreme Court of India. Direct judgment, quoting the very provision, my lord, which was relied upon by the intervener. I don't think, my lord, I can go, but kindly note, my lord, if your lordships are taking note of that, because he relied upon some federal court judgment and said that you cannot examine the reference, etc. And, my lord, this is 1991, volume 4, SCC 406. And paragraph 32,
One minute.
1991,
1991, 4 SCC 406. It's a three honorable judges, Justice Kuldeep Singh. My lord, it's on record. 4584. My lord, I knew somebody would raise this issue. 4584. My lord, para 32. My lord, it's a long para, but it deals.
48,
Your
volume?
511, my lord. Volume 511.
Page 48?
I'm sorry. The relevant or it's
58. 84.
and the relevant at 4626, para 32. Mr. Nariman raised this very argument, which was repelled. That for federal, why, my lord?
What is that?
My lord, it is Delhi Judicial Services Association versus State of Gujarat. Anyway, my lord, whatever. But it's not a point in consideration. Nobody has argued, my lord. At least the states have not. I am also not. My lord, 142 evolves, my lord, from the facts of each case, my lord. But that is fundamentally wrong. And if your lordship holds that it binds, that will be opening floodgates, my lord, because what happened in 1920 and whatever the law laid down in 1920, you start becoming binding. My lord, therefore, this question has arisen and is answered in the negative. My lord, I am immensely grateful, my lords. And my lord, I must say, my lord, I have learnt a lot from all, my lord, Mr. Sibal, Mr. Gopal Subramaniam, Mr. Singhvi, Mr. Datar, everyone, my lord. It's an enriching experience from your lordship's query also, my lord. Every time my lords put a query, my lord, we researched, and my lord, that was an enriching experience. But I'm really thankful for my team, especially Kanu Agarwal. We are as good or as bad as, my lord, our team. My lord, I'm grateful to everyone.
As Mr.
Right, your lordship.
Gopal Sunar rightly put in, you have put in a lot of industry.
Pardon, my lords?
You have put in a lot of industry. He has complimented you yesterday.
Yes, yes. My lord, therefore, my lord, I mentioned Mr. Subramaniam, my lord, specifically right now, that I've learned a lot from everyone, my lord. I'm grateful to your lordship.
Before the age starts, there are three issues which have not been touched now. One is the dating interest. The other which follows is the parent payment.
With regard to?
Dating interest. Dating interest, not because he is the judicial minor.
But then when rejoined, how can we hear you?
He is also an intervener on this.
No, what I am only saying, I have filed written submission, Lord, in one of the IAs which have been, I'm only requesting your lordship to go through that, because it has a bearing, Lord, on the answer to your lordship. That's the only submission I am. Because, why the name of the God has been brought into, while giving the oath, etc., has all been dealt with it.
That's not relevant.
Yes,
It's on this side, my lord, but
Yes, Mr. Solicitor.
only one last line, my lord. One of the question framed is whether Article 32 petition would lie. We have not addressed your lordships in the, my lord. So,
No, at least you have 1.5 hours you have taken for that.
no, it was on justiciability and judicial.
No. Even on maintenance, you have Article 32 and 226.
Then they kindly decide.
Therefore, we have reached up to today. Yeah, otherwise we would have concluded it yesterday.
I bow down. there is no.
For your 1.5 hours, we have to compensate them more than 3 hours and.
My lord, that your lordships are right, my lord. That my 1.5 hour, my lord, cost me a lot, my lord. And your lordships a lot.
There's no question on Article 32. Your lordships can see, there's no question.
Yes.
Yes, Mr.
May I please you?
States have assisted your.
I mean, just as the learned solicitor complimented the assistance given by all the learned counsel. I wish to take your lords a little away from the focus on Article 200 for the time being.
Don't take us beyond the questions which are framed.
I
You
wish
can
to
take
be
us
little
anywhere
away
within
from it for the time.
within the framework of the questions that are framed.
Yes, yes. It's a matter of concern that we're talking about an important provision of the Constitution. And very often when we deal with such important provisions in the matter of rights, restrictions, we also land into questions of moral principles, policies, values, and they sometimes get so jumbled up that we find it very often difficult to disentangle them and to look at only the purely legal principles. Why I say this, in the course of assistance to this court on Article 200, I just want to bring to your lordship's notice a famous Greek mythological figure, Procrustes. Procrustes was a robber in some place called Attica. So he had an iron bed. And so when he catches somebody, if the person who is caught is too larger than the iron bed, he will cut his legs. If the limbs are too shorter, he will stretch his legs. So this phrase became a Procrustean bed mean to try to suit mechanically all possible circumstances so that you fits one particular way of looking at it. So both parties have tried to say, look at either stretch it or shrink it. And that's our duty to tell you, Lordship. But then 200 should not be put into a Procrustean bed. It has a life breath of its own. It is an important value in the entire scheme of the Constitution. And therefore, let us not fall into a trap of saying, for instance, I'll give a syllogism. In logic is something called a syllogism. The Constitution keeper said, keep away discretion from Article 200. Discretion figures in some other part of the Constitution. Therefore, the inference is this. Article 200 devoid of any course of action, independent course of action by the governor. So we have some syllogisms like this, like, let me give some examples. All delays are bad. Governors tend to do delay. Therefore, all governors are bad. We don't have this kind of syllogistic fallacy to assist the court. Or all hippopotamuses four legs.
What is the argument?
I'm coming to Lords. I'm trying to say that how will the court be assisted in trying to look at Article 300? So we don't fall into those fallacies to say, because looking at the Constituent Assembly debates, a certain expression or a word has been removed from it for a certain reason. The entirety, the logic of retaining Article 200 with a governor in place in Article 200, will you completely rob away the constitution makers' understanding as to why we still need, if all those debates in the assembly, discretion dropped, we have doubts about governors becoming super legislative authorities and so on and so forth. After all these debates, Article 200 still finds a position in the Constitution. The constitution makers could have probably said, we will not have governors in Article 200. We will have some other way of looking at whether, after an entire exercise, a responsible legislature has passed a law. Should we need a check on that? What kind of a check could it be? Therefore, if the constitution makers thought we still need to have some kind of a check or a scan on that, I think it's important for us that Article 200 will be given its plenary understanding of not being subject to any shackles. The argument is, please keep it under control, because democracy is important. The legislative wisdom is important. All those principles notwithstanding, if the constitution makers show that the governor will play a role in understanding whether the final word on taking the law to its conclusion, a bill to its conclusion, will lie with the governor, will you say, I will shackle his hands and say, therefore, I will impose as many restrictions as possible so that nothing remains for the governor to make an independent choice in the four options given to the governor? But that's a fundamental question. You're being asked, you're being told that, please limit, constrain it, impose as many restrictions as possible. I would say, please don't do that. All the set of questions are framed on the understanding, please allow a certain amount of independent exercise of judgment by the governor and the president under Articles 200 and 201. That if at all there is an importance of having a scan at a particular point of time before a bill can become a law, please allow it to remain as it is. The moment you say, no, I will exercise a judicial power to say, how will you articulate your power? How will you exercise your independent judgment? Then you are entering into not only rewriting the Constitution, but you're entering into opening up a whole range of what you will call a new jurisprudence on governor's assent. The endless exercise and involvement, engagement of what the court will do and what court will not do, who can ask the court to do what, all those questions, justiciability, jurisdiction, maintainability, writ petition, all that will come in. You can't stop it. No court can stop it. We are lots to give an illustration about fixing timelines on medical college admissions. So once you open up a certain things for a certain consideration by the court, Dworkin used to call about judges that they are not deputy legislators. So once all this happens, the court will become something like a deputy legislator, stepping into the shoes of the governor or the president, as the case be in some case or the other. So you're talking about the importance of the subject. The president's reference questions are based on this understanding, namely, whether we have a Tamil Nadu judgment which has certain difficulties or not is not the question. Therefore, right from the Special Courts Bill, this court has said, if a judgment has to be reconsidered, it will certainly be reconsidered. It will not be overruled in the sense by an adjudicative process, because it is not the correct view of law, which will enable party, legislature, executive, parliament. But that's how it has to be seen. That's my larger say on the relevance of the reference. Then I have some questions on how will you therefore look at Article 200 itself. I'm not going to take a lot from the text of the provision. But before I do that, I think it's important to invite Lord's attention to a very civil observation made by Justice Holmes in a dissent in a 1907 judgment. That is in the context of hard cases. I just propose to read that. If I will also take my supplementary written submission. Paragraph. It is volume 1.11. Paragraph 38 at page 902. Because too many statements have been canvassed here saying, generalizing several propositions about judicial review. So kindly turn to that, page 902, paragraph 38. That entire dissent is very instructive, but I'm only extracting one important part of the dissent. The voice of dissent in so-and-so is worthy of consideration. Great cases, like hard cases, make bad law. For great cases are called great, not by reason of their real importance in shaping the law of the future, but because of some accident of immediate, overwhelming interest, which appeals to the feeling and distorts